Contracts. When we study contracts, look at Articles 1305 to Article 1422 of the new Civil Code. When we speak of contracts, we have to first establish ano ba talaga ang contract. Okay? According to 1305, a contract is a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Okay? Yan ang very clear definition ng contract because ang ating 1305 clearly defined it. Okay? It lays emphasis on the meeting of minds between two contracting parties which takes place when an offer by one party is accepted by the other, according to Article 1319. So dito, ang emphasis is meeting of minds between two contracting parties na pinapakita rito na nag-o-offer yung isang party at tinatanggap ng isang party. Ano ba ang diferensya ng contract and obligation? Contract is one of the sources of obligation. Very clear. Napag-aralan na natin yan. Article 1157. On the other hand, pag sinabi niyong obligation, it is the legal tie or relation itself that exists after a contract has been entered into. So, ang laki ng diferensya nun. Yung isa, sources of obligation or one of the sources of obligation. While on the other hand, obligation is the legal tie. It is the juridical necessity to give something to do or not to do. Okay? Hence, there can be no contract if there is no obligation. But an obligation may exist without a contract. Alalahanin nyo, 5 ang sources nun. So, kahit walang contract, merong obligation. Pero ang tanong, meron bang contract kung walang obligation? Then the answer is no. Okay? O, ano naman ang diferensya ng contract and agreement? What are the differences? When you say contracts are agreements enforceable through legal proceedings. Okay? These are enforceable through legal proceedings. Yan ang ibig sabihin, yan ang kaibahan ng contract because agreements which cannot be enforced by action in the courts of justice are not contracts but merely moral or social agreements. Ano ba example nito? Halimbawa, nag-usap kayong dalawa magkaibigan or magka-classmate. Sabi nyo, punta tayo ng coffee shop, punta tayo ng Starbucks. Okay? There is an agreement. However, may contract ba? Well, technically speaking, wala. Because hindi siya enforceable under the courts of justice. An agreement is broader than a contract because the former, the agreement, may not have all the elements of a contract. Pag-aaralan natin yung elements ng ating kontrata. Okay? Now, what else? Freedom to contract. Sigurado yan, guaranteed. Okay? The right to enter into contract is one of the liberties guaranteed to the individual by the Constitution. However, the constitutional prohibition against the impairment of a contractual obligations refers only to legally valid contracts. Pinag-uusapan dito, last, remember, pinag-uusapan, lahat ng tao pwede, meron kayong freedom to enter into a contract. Ang pinagbabawalan lang dito, or ang sinasabi lang na ina-allow dito are legally valid contracts. Hindi pwede na pumapasok lang kayo sa kontrata for the sake na pumapasok kayo. And that is okay. However, meron din tayong mga limitations. Okay? You should have a limitations in your contractual stipulations wherein kailangan alam nyo yung limitations. Like, Kailangan yung batas, alam nyo. It is important that you should know the law before entering into a contractual stipulations. It is fundamental requirement that the contract entered into must be in accordance with and not repugnant to an applicable statute. Hindi dapat kumukontra sa batas. Dapat in accordance, dapat alinsunod sa ating mga batas. Dapat ang terms are embodied in every contract. Kaya di ba, class, kung mapapansin, napakahaba ng kontrata because everything should be written in the contract. Okay? But, in a way, it is the law that sets the limit. Okay? May limitation lang naman. Pag sinabi ng batas, halimbawa, of course, simple lang, trade. You can trade anything. Pwedeng cigar, pwedeng alcohol, but not drugs. Diba? Ito may mga regulation na tinatawag, nililimit. Pwede ang alak, pwede ang sigarilyo, pero wag naman drugs. These are classic examples of contractual stipulations wherein a law or the law regulates the contractual stipulations. Okay? Number 2, yung tinatawag nating police power. Assuming there is no law in existence or when the law is silent, the will of the parties prevails unless their contract contravenes the limitation of morals, good customs, public order, or public policy. In short, all contractual obligations are subject as an implied reservation therein for the possible exercise of the police power of the state. Meron kasi tayong tinatawag na police power of the state. Ito yung karapatan ng ating gobyerno na i-regulate ang anumang contractual stipulations kung kung kanilang madidiscover at mapapansin ng inyong mga pinag-uusapan ay against sa tinatawag nating morals, good customs, public order, at public policy. Okay? So, ano-ano ba to? Ano-ano ba yung mga example na to? Halimbawa na lang, yung tinatawag nating contrary to morals. Kasi pag sinabi mong morals, it deals with norms of good and right conduct evolved in a community. These norms may differ at different times and places with each group of people. Okay? So, yan yung atin sa morals. Di ba? Ito yung norms of good and right conduct evolved in a community. Example, a contract whereby X promised to live as the common law wife of Y without the benefit of marriage in consideration of 100,000 pesos. Ito, class, immoral na, therefore void. Di ba? Kasi hindi naman pwede na may pera at kabayaran, tumira ka lang at hindi pa kayo kasal. Di ba? That is against our morals. Thus, the police power of the state may intervene and invalidate the contract. Okay? What else? Contract must not be contrary to good customs. Customs consist of habits and practices which through long usage have been followed and enforced by society, or some of it as binding rules of conduct. It has the force of law when recognized and enforced by law. Ulitin ko, class, ha? Ang customs, ito yung habits and practices na sa tinagal-tagal na paggamit at tagal na gamit at sinusunod naman ng ating society. In a way, it is already or it forms part as rule of conduct. Thus, it may be recognized and enforced by law. Example, si X entered into a contract whereby X binds himself to slap his father. Of course, this contract is void because it is against a good custom of showing respect to our parents. O syempre naman, tatay mo, papasampal ng iba. Eh, di ba, hindi naman yon. It's good custom. It is considered a good custom. Tatay mo yun eh. Okay? In fact, dito sa Pilipinas, yung paggamit ng po at opo ay major yon. It is already considered a good custom. Pero sa ibang bansa, hindi. Kaya ang application ito is also dependent on the areas na pinag-uusapan natin. Okay? Ano pa? Public order. Public order refers principally to public safety, although it has been considered to mean also public will. Public will. W-E-A-L. Public will. Okay? So, anong example na pwede nating gamitin when we speak of public order? Okay? Example, a stipulation in the contract of lease whereby the landlord can use force to eject the tenant in case of failure of the latter to pay the rent agreed upon is void as being against public order. Okay, nakalagay sa kontrata, ikaw ay nagre-rent. Nagre-rent ka, pero nakalagay doon, pag hindi ka nagbayad, pwede kang i-eject o tanggalin by force. Okay, pwede kang tanggalin by force. So, paano pagtanggal by force? Paano ba usually yan? Tatanggalin yung mga gamit mo. Tatanggalin ang mga gamit mo, itatapon or ipapadlock ang bahay mo. Okay? So, that is considered against public order. Pag sinabi mong pinadlock pero tinapon mo yung mga gamit mo, pwede mong ipadlock. Yung iba actually pumapayag na may padlock pag hindi ka nagbayad. Pero yung tatapon pa yung mga gamit mo, ay ibang usapan na yun. Okay? Now, public policy. When we speak of public policy, ito ay broader than the public order because ang kinoconsider lang ng ating public order is yung public safety, but also considerations which are moved by the common good. A contract which has a tendency to be injurious to the public or is against public good is contrary to public policy. Though actual injury, hindi naman kailangan. Okay? Example, para mas maintindihan natin. X stole the car of Y. Later, they entered into a contract whereby Y will not prosecute X in consideration of 50,000. It is to the interest of the society that crimes must be punished. The agreement between X and Y is therefore contrary to public policy because it seeks to prevent or stifle the prosecution of X for theft. So, ganun yun, class. Diba? Eh, may kasalanan eh. Pero dahil nagpabayad ka, it's against public policy. Hindi mo pwedeng ilagay yon sa contractual stipulations. Okay? Kasi kaso yon pag nanakaw. So, dahil lang babayaran ka na lang ng 50,000, mananahimik ka na. Hindi, dapat parusahan natin. Because remember, class, theft or crimes are not personally against you. Okay? Kasi, class, ang mga krimen ay hindi lang sa'yo kaso kung hindi against the state. Okay? Lalo na yung mga violation ng ating revised penal code. Pag may na-violate doon, ito ay also considered as crimes against the state. Okay? So that is public policy, public order, good customs, morals, and law. Now, ano ba yung mga iba't ibang classification natin ng contract? According to name. Ano ba yung mga according to name? Pwedeng nominate and innominate. According to perfection, pwedeng consensual and real. According to cause, ito yung onerous, remunatory, and gratuitous. According to form, informal or common, and formal or solemn. Tapos, according to obligatory force. Ito naman yung valid, rescissible, voidable, iisa-isahin natin yan, unenforceable, void, or inexistent. According to person obliged, unilateral, and bilateral. According to dependents in another contract, ito yung preparatory. When it is entered into as a means to an end, pwede rin siyang accessory. When it is dependent upon another contract, it secures or it guarantees for its existence and validity. Ibig sabihin, merong hindi siya tatayo sa sarili niyang paa. Pwedeng, of course, yung principal. When it does not depend upon its existence and validity upon another contract. Pero ito ay indispensable condition for the existence of an accessory contract. According to risk, commutative, when the undertaking of one party is considered the equivalent of that the other. Aleatory, depends upon uncertain event or contingency, both as to benefit or loss. Okay? Yung commutative, ito yung mga example dito, sale and lease. Sa aleatory, ito yung insurance or sale of hope. And last but not the least, according to liability, unilateral or bilateral. Okay? Nasabi mong unilateral when it creates an obligation on the part of only one of the parties. And bilateral when it gives rise to reciprocal obligations for both parties. Okay? So, based on our classification of contracts, ang ating i-discuss na susunod is according to name or designation and according to perfection before we move on dun sa requisites of a contract. Okay? This is the first part and this is the introduction.